All rise, we are good away. The International Residual Mechanism for Criminal Tribunals is now in session. Lors d'audience du mécanisme international appelé à exercer la fonction résiduelle de tribunaux pénaux et ouverts. Please be seated.
Good morning, ladies and gentlemen. Are we
Madame
connected?
Juge la présidente. Bonjour, mesdames et
Good morning, Your
messieurs.
Honors. Yes, we are
Est-ce que
connected.
vous m'entendez? Le greffier d'audience. Bonjour, madame le juge. Oui,
Okay.
nous vous entendons bien.
As some of us are participating in this hearing through a
Sachant que
video
certains d'entre
conference
nous
connection,
participent à cette audience par voie de visioconférence,
I would like to emphasize that
je
only
tiens à
persons who are
souligner que
speaking
seule
may
la
have their
personne qui est
microphone
en train
turned
de
on.
s'exprimer est autorisée à brancher son micro.
All others, kindly keep your microphones off
Quant aux autres
until
participants,
such time
je
as you are
serai
invited to
reconnaissante de
speak.
bien vouloir débrancher le micro jusqu'au moment où vous aurez la parole.
Thank you for your cooperation. We will now
Merci pour
proceed.
votre coopération. Nous allons maintenant commencer le procès en appel.
Madam Judge, we're getting the French channel mixing into the English channel.
La défense.
That is
Madame
correct.
le juge, nous entendons l'interprétation vers le français sur le canal anglais. Madame le juge, en effet.
Can I proceed?
La présidente, puis-je continuer?
Very well.
We are looking into the
Registrar,
issue.
could you please call the
Le
case?
greffier d'audience, nous sommes en train d'étudier le
Good morning, Your
problème.
Honors. This is case
La
MICT
présidente,
13-56-A.
veuillez
The
citer
prosecutor
le
was
numéro de
Ratko
l'affaire, s'il vous plaît,
Mladić.
le greffier d'audience. Bonjour, Madame la présidente, messieurs les juges, ceci est l'affaire MTPI 13-56-A, le procureur contre Ratko Mladić.
The interpreters are really bothered by the French they hear all the time.
Les interprètes de la cabine anglaise, les interprètes trouvent qu'il est très problématique d'entendre tout le temps l'interprétation vers le français.
Your Honors, my IT colleagues are looking into the issue. We will get back to you regarding the
Le
interpreter
greffier
channels.
d'audience, Madame la présidente, messieurs les juges, mes collègues sont en train d'étudier le problème et nous vous ferons savoir ce qui se passe.
This is a test 1, 2, 3. This is a test 1, 2, 3. Is the situation better now? Yeah. Test 1, 2, 3. Testing 1, 2, 3. Your Honors, I can report the situation has been resolved. Thank you. Madam Presiding Judge, the situation has been resolved.
page, please, and click on link here.
Okay. I think we're online. Sorry, just we're online. Okay. All right.
Looks like. Good morning. Are we connected? You can hear me now?
Good morning, Madam Presiding Judge. We can hear you. You can proceed now. The issue has been resolved.
Okay. So we start again. Good morning, ladies and gentlemen. As some of us are participating in this hearing through a video conference connection, I would like to emphasize that only the person who is speaking may have their microphone turned on. All others, kindly keep your microphones off until such time as you are invited to speak. Thank you for your cooperation. We now proceed. Registrar, could you please call the case?
Thank you and good morning, Your Honors. This is case MICT-13-56-A. The prosecutor was Ratko Mladić.
Thank you. Mr. Mladić, can you follow the proceedings in a language you understand?
Mr. Mladić has said he's not hearing anything.
I know that even Judge Patton cannot hear anything. All right. Can everybody hear me?
Yes, Judge, we can hear you
I'll
loud
start
and clear.
again. Sorry?
Madam Presiding Judge, we can hear you loud and clear.
Okay. Registrar, could you please call the case?
Yes, this is case MICT-13-56-A. The prosecutor was Ratko Mladić.
Thank you. Mr. Mladić, can you follow the proceedings in a language you understand? I hear no response from Mr. Mladić. Can please somebody give him the microphone?
Evo, pratim na mom jeziku ovo dešavanje.
I heard Mr. Mladić speak, but I did not get the translation of what he said.
I can follow the proceedings in my language.
Sorry?
I can follow the proceedings in my language.
Nemam prevod, što govori gospođa.
I'm not receiving any interpretation.
I take it you are saying you can follow the proceedings in a language you understand.
Da, sad.
Yes, I can now.
Thank you. Let me now ask for the appearances of the parties. First, the prosecution.
Good morning, Your Honors. Laurel Baig and Barbara Goy for the prosecution. We're joined by our case manager, Janet Stewart, and today we'll be joined in the courtroom by three of our colleagues right now. That is Rafael Braga da Silva, and later in the day, Maria Yakusheva and Catherine Marsden. Thank you.
Appearances for the defense?
Good morning, Madam Presiding Judge and Your Honors. Appearing for the defense, Dragan Ivetic, co-counsel for Mr. Mladić, and I'm joined in court by Peter Louise Bagot, legal consultant for Mr. Mladić. Thank you.
Thank you. As a preliminary matter before calling on Mr. Mladić's counsel, I note that defense have requested through a letter to the appeals chamber senior legal officer that their assigned legal consultants, Ms. Peter Louise Bagot and Mr. Boris Zoko, respectively be granted a right of audience during the appeal hearing. These requests have been unopposed. I further note that in submitting this request, counsel for Mr. Mladić provided letters from the Office of Legal Aid and Defense Matters of the mechanism demonstrating that Ms. Bagot and Mr. Zoko have been officially assigned as legal assistants to Mr. Mladić's legal team. In these circumstances, the appeals chamber grants Ms. Bagot and Mr. Zoko a right of audience at the present hearing. Now, counsel for Mr. Mladić, sorry I called you before. Thank you.
Thank you.
Mr. Mladić and yes, Mr. Mladić and the prosecution have both appealed against the judgment rendered on 22 November 2017 by the Trial Chamber 1 of the International Criminal Tribunal for the former Yugoslavia. On 16th December 2019, the appeals chamber scheduled the appeal hearing to take place on 17 and 18 March 2020. This hearing was stayed on 6th March 2020 on the basis of Mr. Mladić's request regarding his then upcoming surgery and recovery. On 1st May 2020, the appeals chamber noted Mr. Mladić's progress in recovering from surgery and scheduled the appeal hearing to take place on 16 and 17th June, subject to change in light of coronavirus pandemic-related restrictions. On 28 May 2020, the appeals chamber further stayed the scheduled appeal hearing, given the unavailability of counsel and complications arising from the coronavirus pandemic-related restrictions. On 17th June 2020, the appeal chamber scheduled the present hearing. This case concerns the criminal responsibility of Mr. Mladić, who was appointed commander of the main staff of the, oops. This is nonsense. Theo? Right, we are reconnected. As I was saying, this case concerns the criminal responsibility of Mr. Mladić, who was appointed commander of the main staff of the Army of Republika Srpska, the VRS, on 12 May 1992 by the Bosnian Serb Assembly. Mr. Mladić remained in command of the VRS main staff until at least 8 November 1996. The trial chamber convicted Mr. Mladić pursuant to Article 7.1 of the ICTY Statute of genocide, crimes against humanity, violations of the laws or customs of war. In particular, the trial chamber concluded that from 12 May 1992 until 3 November 1995, Mr. Mladić participated in the overarching JCE, a joint criminal enterprise with the objective of permanently removing Bosnian Muslims and Bosnian Croats from Bosnian Serb-claimed territory in Bosnia and Herzegovina through persecution, extermination, murder, inhumane acts, forcible transfer, and deportation. The trial chamber convicted him of these crimes. The trial chamber found that between 12 May 1992 and November 1995, Mr. Mladić participated in a joint criminal enterprise with the objective of spreading terror among the civilian population of Sarajevo through a campaign of sniping and shelling. The trial chamber convicted him of the crimes of terror, unlawful attacks on civilians, and murder. The trial chamber also found that from the days immediately preceding 11 July 1995 to at least October 1995, Mr. Mladić participated in a joint criminal enterprise with the objective of eliminating the Bosnian Muslims in Srebrenica by killing the men and boys and forcibly removing the women, young children, and some elderly men. It convicted him of the crimes of genocide, as well as persecution, inhumane acts, forcible transfer, murder, and extermination. Finally, the trial chamber found that from approximately 25 May 1995 to approximately 24 June 1995, Mr. Mladić participated in a joint criminal enterprise with the objective to capture United Nations personnel deployed in Bosnia and Herzegovina and detain them in strategic military locations to prevent the North Atlantic Treaty Organization from launching further military airstrikes on Bosnian Serb territory targets, military targets, sorry. It convicted him of the crime of hostage taking as a violation of the laws or customs of war. The trial chamber sentenced Mr. Mladić to life imprisonment. Mr. Mladić advances 9 grounds of appeal with numerous subgrounds challenging his conviction and sentence. He requests that the appeal chamber reverse erroneous findings of the trial chamber, quash his convictions, and acquit him. In the alternative, Mr. Mladić seeks a retrial or a reduction in his sentence. The prosecution responds that Mr. Mladić's appeal should be dismissed in its entirety. The prosecution presents 2 grounds of appeal, challenging certain findings or conclusions of the trial chamber, including its acquittal of genocide in relation to the overarching JCE. The prosecution requests that the appeal chamber correct the trial chamber's errors and convict Mr. Mladić of genocide under the count 1 of the indictment, pursuant to the first category of joint criminal enterprise, or alternatively, the third category of joint enterprise, or as a superior under Article 7.3 of the ICTY statute. Mr. Mladić responds that the prosecution's appeal should be dismissed in its entirety. I now summarize the manner in which we will proceed. I would like to remind both parties that the appeal process is not a retrial de novo, and the parties must refrain from repeating their case as presented at trial. The arguments must be limited to alleged errors of law which invalidate the trial judgment, or alleged errors of fact which occasion a miscarriage of justice. Throughout the hearing, the parties may present the grounds of appeal in any order they consider suitable. The parties shall present their submissions in a precise, clear, and concise manner, and should also provide precise references to materials supporting their oral arguments. It's okay? Right. I would also like to remind both parties to particularly careful not to reveal any confidential information, including information that could identify protected witnesses. As set out in the 17th July 2020 decision, the hearing schedule has been adjusted to ensure the safety of all those participating in person, and we will adjust it further to ensure that all breaks are 1 hour long to allow for thorough cleaning and ventilation. The hearing today and tomorrow will proceed as follows. Today we shall first hear the submissions in support of Mr. Mladić's appeal for 1 hour. After a pause of 1 hour, we shall continue to hear the submissions in support of Mr. Mladić's appeal for 1 hour. Then after a pause of 1 hour, counsel for Mr. Mladić will have another hour to make submissions. After a 1 hour break, the prosecution will respond for 1 hour. Following a pause of 1 hour, the prosecution will continue its response to another hour. Tomorrow, starting at 9:30 a.m., the prosecution will have 1 hour to finish its response. After a pause of 1 hour, counsel for Mr. Mladić will have 1 hour to reply to the prosecution's response. This will be followed by a pause of 1 hour, after which we will hear the final 30 minutes of reply submissions in support of Mr. Mladić's appeal. Directly following this, we shall hear the prosecution's appeal submissions for 30 minutes. After a pause of 1 hour, counsel for Mr. Mladić will respond to 30 minutes for 30 minutes. Subsequently, the prosecution will have 15 minutes to reply. Finally, Mr. Mladić will have 10 minutes for an optional personal address. Now, I would like to invite counsel for Mr. Mladić to present his appeal. You have 1 hour for this part of the submission.
Good morning and thank you, Madam Presiding Judge. Before I begin, I must place on the record that during the submissions that you just made in the courtroom, we had about several minutes of loud English being broadcast, and Mr. Mladić complained that he had difficulty following the proceedings due to the same, but that has now been resolved. Your Honors, before we begin with the appeal, I am mandated to put on the record pertinent information, objections, and reservations of rights to protect Mr. Mladić's interests and explain my presence. Lead counsel Lukic and legal consultant Zorko from Serbia are unable to attend based on consultation of their ethical code and bar, which prevents them from acting against the explicit instructions of their client, and absent waiver prevents them from substituting their own interests over the rights of the client. Likewise, the risk of travel bringing illness to the client. Lastly, the Serbian Code and Bar have a very strong stance forbidding purely video link proceedings in this matter. These statements, and my own, are made from a difficult position, imposed by the majority decisions on our most recent filings to press on with these proceedings without a legal competency hearing as to Mr. Mladić. Upon consultation and discussion with the Ethics Board lawyers of the Illinois Supreme Court Attorney Registration and Disciplinary Commission, and upon diligent review and study of the relevant rules of conduct they referred me to, as well as pertinent substantive legal literature and jurisprudence relating to the same, I have been reminded of my ethical and professional duties that are partly in conflict with the majority decision to proceed with the appeals hearing today. In light of a bona fide, reasonable conclusion as to my client's ill health and inability to meaningfully prepare and take instructions from him, and a reasonable belief in his diminished capacity, I am personally and professionally required to make a strong record objecting to the majority decision and this appeals hearing today. Under my domestic, ethical, and professional obligations and case law, this hearing today is inappropriate and threatens, as Presiding Judge Nyambe stated in her dissent, a miscarriage of justice, such that I cannot abide to be a silent participant in this questionable proceeding. My presentations during the last status conference and the defense's subsequent written filings on the record have all been undertaken in accord with the Model Rules of Ethics, comments 1.14, etc., and also Illinois Rules of Professional Conduct 1.14, etc., dealing with diminished capacity clients. Lengthy consultations with my ethics board and diligent review of the prevailing authorities on this matter mandate my further action as follows. Aware of my role as an officer of the court and concerned about not misleading the court, counsel, such as I, must seriously question the propriety of allowing my impaired client and myself to proceed today when competency issues remain unresolved. Here I would direct you to Bennett, a guided tour through selected American Bar Association standards relating to incompetence to stand trial. 53, George Washington Law Review, 375 at pages 383 to 384, 1985. The American Bar Association Criminal Justice Mental Health Standards, particularly 7-4.2, requires me as defense counsel to raise competency even if that may conflict with obligations to the court. To do otherwise, I would violate my jurisdiction's ethical professional standards and I would betray my client's interests. Further, I note that both the prosecutor and judges have that same ethical and professional obligation to prevent the legal process from being demeaned by proceeding against an incompetent defendant. Her Honor, Presiding Judge Nyambe, and the defense have acted in accord with the professional obligations placed on us as officers of the court. The client, Mr. Mladić, has ultimate authority to determine the purposes served by his counsel, especially on appeal, where significant decisions are made. I am unable to meaningfully gain instruction from Mr. Mladić, nor be assured that he is able to meaningfully participate and follow same, owing to the majority decision. Under these circumstances, the authorities consulted in my home jurisdiction dictate that I, the attorney, should protect the due process rights of the alleged incapacitated individual and advocate strenuously for my client's wishes. If I, the attorney, do not do so, the alleged incapacitated person has no voice in these proceedings, This is an ethical obligation of I, the attorney, as an officer of the court, which also protects these proceedings from attack based on due process violations, here contained in the statute of the IRMCT and the jurisprudence. Thus, I must make this objection and make a record of the majority's error and its consequences. It is a denial of due process to sentence or proceed criminally against someone who is incompetent to stand trial. And at that point, the court should, on its own initiative, conduct a hearing on that matter. I will cite 3 United States Supreme Court cases. Pate v. Robinson, 1966. Dusky versus United States, 362 U.S. 402, 1960, per curiam, cited with approval in Indiana versus Edwards, also the Supreme Court, 2008. Second, there is a presumption that psychiatric and other medical examinations will be included in the decision-making process. Mata versus Johnson, United States Court of Appeals, 5th Circuit, 2000, citing the U.S. Supreme Court in Reyes v. Payton, 384 U.S. 312, 1966. Even assuming arguendo that a court has not received evidence raising a bona fide doubt as to competency, my Supreme Court mandates that courts indulge every reasonable presumption against waiver of fundamental due process rights. Mata versus Johnson, again from the U.S. Court of Appeals, 5th Circuit, 2000, citing to the U.S. Supreme Court in Hodges versus Easton, 106 U.S. 408 at page 412. In the instant case, Mr. Mladić, the majority, without medical expert examination on this matter, have forced me to this untenable position of proceeding with the appeal hearing in violation of all the aforesaid legal tenets from my domestic jurisdiction, and in some cases in violation of domestic and professional ethics standards in other jurisdictions, which is why counsel Lukic and consultant Zorko cannot attend today, as to do so would place them in violation of their domestic ethics code and licensing body. Therefore, my presence here today as co-counsel is under a continued objection, protest, and strongest possible reservation of rights. My client has not waived any of his rights, nor have I or counsel Lukic, as his counsel, waived his rights in his stead. We cannot, as to do so would infringe upon his due process rights. Your Honors, my presence here today is of a limited scope, and again is due to the majority decision. I am professionally unable to fully present the appeal as envisaged, nor obtain meaningful participation, nor instruction from my client due to the position of the majority having placed on me. I, in accordance with my ethical duties, and after consultations with my home ethics bar and review of relevant and authoritative jurisprudence and literature, do not consent to this being the ultimate appeals hearing, and will undertake to preserve all my client's rights to a repeated proceeding if and when he has undergone a capacity review that finds him competent to do so. I note, in light of the strongly worded dissent of Presiding Judge Nyambe, that proceeding in this way may be regarded as a miscarriage of justice, threatening the integrity of these proceedings without any medical expert testimony as to the current mental fitness and capacity and ability to meaningfully participate of Mr. Mladić. Based on the same, Mr. Mladić does not waive his right to have a full appeal hearing on another date. I do not waive rights to any part of the appeal, and I engage today in a limited capacity in good faith as an officer of the court, and in accordance with my consultations with the Domestic Ethics and Licensing Bar of Illinois and the Federal Court of the United States. Subject to this objection and reservation of rights, I now defer to my colleague to make a record of the substance of the appeal to the extent that she and I are able to do so today under these circumstances. And I thank you very much, and I pass the floor to Ms. Bagot.
Good morning, Madam Presiding Judge, Your Honours. Mr. Ivatic and I will be making submissions on behalf of Mr. Mladić on the grounds of appeal set out in the appeal brief. We invite the Chamber to overturn Mr. Mladić's convictions entered by the trial chamber on the 22nd of November 2017. We do not intend to make submissions on every ground and every subground in the appeal brief. Given the size of the appeal and the detailed and comprehensive written submissions the Chamber has already received in the form of the appeal brief and the reply to the prosecution's response, we are addressing the Chamber on selected grounds. I will be addressing the Chamber on grounds 1, 2, and 4 of the appeal brief. Mr. Ivatic will be addressing the Chamber on grounds 3 and 5 and making our concluding remarks. Before turning to the substance of this appeal, we wish to make a few introductory remarks. International criminal courts and tribunals are unusual institutions. Decisions made by the tribunal has an impact that extends beyond purely legal outcomes. The consequences of a conviction, or dare I say it, an acquittal, has an impact that extends beyond these four walls. For many, convictions are seen as a victory and acquittals a failure. Not only do the prosecution come under scrutiny when convictions are not secured, but criticism is directed towards the judiciary. It is the fact that the application of the black letter of the law can in some way be interpreted as betraying the interests of justice that makes international criminal courts and tribunals so unusual as legal institutions. They are they not, just criminal courts hearing criminal trials at the end of the day. It is trite to say, but an important reminder, that trials before this tribunal require the same strict application of the burden and standard of proof as any other criminal trial. They require the same unflinching application of the presumption of innocence at every stage of the process. If the prosecution fails to discharge its burden of proof, then the accused must be acquitted. The law is dispassionate in this sense. As Justice Jackson made it clear in his opening statement at the Nuremberg trial, quote, "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice." End quote. When international criminal trials were in their infancy, there was a clear recognition and understanding that the application of the law should be rooted in fairness. Both in the past and the present, it is understood that justice cannot be served if corners are cut and due process norms are cast to one side. When judges at this tribunal are sworn in, they take an oath to honourably, faithfully, impartially, and conscientiously perform their duties and exercise their powers. Incumbent upon the judiciary is a heavy burden to make often difficult and unpopular decisions to give effect to what is right as a matter of law. What we invite the Chamber to do may not be easy or popular, but in our submission, it is right. It is right because it will represent the dispassionate application of the law. It is right because it will represent that this Chamber recognises that the fundamental principle of a right to a fair trial is more than just empty rhetoric. During the course of this appeal, Mr. Ivatic and I will address the trial chamber's errors. Some, as this chamber will have
Ms.
seen...
Begot, we have lost the presiding judge. Could you kindly wait till we reconnect?
Of course. Do we know at which point?
We are back. You can hear me? You can hear me now?
Yes, Judge, we can hear you now. We are reconnected. Thank you.
Sorry, Miss Bagot, they said my connection dropped. You may continue.
Madam Presiding Judge, please could you let me know where we were at before the connection broke?
You were at the point where you were reminding us about the fact that the decisions of this tribunal will transcend to many borders, or something to that effect. I don't have a copy of the transcript, so I think we start from where you're saying which counts you are going to deal with.
I'll go back.
Yes.
So I will be addressing the Chamber on grounds 1, 2 and 4 of the appeal brief. Mr. Ivatic will be addressing the Chamber on grounds 3 and 5 and making our concluding remarks. Before I turn to the substance of this appeal, we wish to make some introductory remarks. International criminal courts and tribunals are unusual institutions. Decisions made by their tribunal have an impact that extends beyond purely legal outcomes. the consequences of a conviction, or dare I say it, an acquittal, has an impact that extends beyond these four walls. For many, convictions are seen as a victory and acquittals a failure. Not only did the prosecution come under scrutiny when convictions are not secured, but criticism is directed towards the judiciary. It is the fact that applying the black letter of the law can in some way be seen to be betraying the interests of justice that makes international criminal courts and tribunals so unusual as legal institutions. They are they not, just criminal courts hearing criminal trials at the end of the day. It is trite to say, but an important reminder, that trials before this tribunal require the same strict application of the burden and standard of proof as any other criminal trial. They require the same unflinching application of the presumption of innocence at every stage of the process. If the prosecution fails to discharge its burden, then the accused must be acquitted. The law is dispassionate in that sense. As Justice Jackson made it clear in his opening statement at the Nuremberg trial, we must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice. When international criminal trials were in their infancy, there was a clear recognition and understanding that the application of the law should be rooted in fairness. Both in the past and the present, it is understood that justice cannot be served if corners are cut and due process norms are cast to one side. When judges at this tribunal are sworn in, they take an oath to honourably, faithfully, impartially, and conscientiously perform their duties and exercise their powers. Incumbent upon the judiciary is a heavy burden to make often difficult and unpopular decisions to give effect to what is right as a matter of law. What we invite the chamber to do may not be easy or popular, but in our submission, it is right. It is right because it will represent the dispassionate application of the law. It is right because it will represent that this chamber recognises that the fundamental principle of a right to a fair trial is more than just empty rhetoric. During the course of the appeal, Mr. Ivetich and I will address the trial chamber's errors. Some, as this chamber will have seen from the appeal brief, are also substantive legal errors that for many years successive appeals chambers have shied away from grappling with. The errors identified in the appeal brief the appellant submits infect all the convictions, such that those entered by the trial chamber on counts 2 to 11 of the indictment should be reversed and not guilty verdicts entered. Ground 1. The appellant submits that the trial chamber erred by holding Mr. Mladić criminally responsible for what the appellant has termed unnamed, unscheduled incidents. The appellant's written submissions are at paragraphs 41 to 60 of the appeal brief and paragraphs 8 to 14 of the reply. To assist the chamber, my submissions will focus on, first, how the appellant defines unnamed, unscheduled incidents. Second, the issue of notice. Third, the fact that the error was not remedied through the presentation of a general defence or cross-examination. And finally, the impact of the trial chamber's error. Definition. Scheduled incidents are incidents that are identified in a schedule attached to the indictment. They are numbered, named, and listed in black and white. Notice is given that they form part of the allegations against the accused by the very fact that they are annexed to the indictment. Unscheduled incidents are incidents that can be relied on by the prosecution to prove material elements of the crime, for example, a course of conduct. Notice of these is given in, for example, the 65-ter witness list, in which the prosecution explicitly states that a witness will be called to give evidence on an, quote, unscheduled incident, close quote. Examples of this include RM 109, page 222 of the 65-ter witness list, at paragraph 3, quote, the witness can also testify to his personal participation in the investigation of unscheduled incidents of sniping and shelling, close quote. RM 138, page 219 at paragraph 6, quote, the state hospital was targeted with shell and mortar fire, brackets, unscheduled, close brackets, close quote. Here, the fact that the witness would give evidence on what the prosecution considered to be an unscheduled incident was explicitly identified as such. Unnamed unscheduled incidents are something quite distinct. They are incidents that do not fall in either of the aforementioned categories. What they are, in fact, are incidents that witnesses made accusations about at trial in the course of their evidence on scheduled incidents or other defined subjects, but which no notice was provided to the defence that they were in fact incidents, either scheduled or unscheduled, for which Mr. Mladić could be held responsible. To highlight this distinction, it's useful to go back to basics with an example. An accused stands trial for incident 1. Witness A is called to give evidence about incident 1. In the course of this, they make additional accusations against the accused. These are not charged. In an adversarial trial, a trier of fact could not enter convictions on these other accusations. The prosecution would have to put the defence on notice that it sought to add them to the indictment before any convictions could be entered. This general principle remains unchanged in an international criminal trial. Before convictions can be entered, notice must be given. Mere accusations fall outside the scope of the indictment. Contrary to the prosecution's submissions at paragraph 6 to 13 of its response, this issue is not about the indictment being defective. The issue is that an indictment cannot be expanded to include any accusations made during the course of a trial. This, we say, is the trial chamber's error. It convicted Mr. Mladić of such accusations that were never identified as scheduled or unscheduled incidents. Notice. As set out previously, when the prosecution sought to call a witness to give evidence about an unscheduled incident, it specified this, and in doing so gave notice to the defence that Mr. Mladić could be held criminally responsible for these incidents. It follows, therefore, that the appellant withdraws incidents for which the defence received notice of in this manner from the Chamber's consideration. In contrast to the approach taken to unscheduled incidents, the defence did not receive notice of unnamed unscheduled incidents. The first time that the defence was made aware that these accusations were being treated as unscheduled incidents was when the judgment was rendered. It was the trial chamber that referred and identified them as unscheduled incidents, not the prosecution. By way of example from the appellant's brief at paragraph 48, incidents Srebrenica Incident U, opportunistic killings, 13th to the 14th of July, 1995. Sniping Incident E, 31st of March, 1993. Srebrenica Incident W, 23rd of July, 1995. Srebrenica Incident, Sniping Incident K, 9th of November, 1993. Shelling Incident D, 14th of May, 1992. Cruel and Inhumane Treatment Incident J, II, 31st of May, 8th of June, 1992. Unlawful Detention Incident E, III. For each of these, the 65-ter list did not make any reference to these accusations as unscheduled incidents in the summary. In fact, the accusations simply form part of the narrative on the scheduled incident or defined subject matter the witness was called to give evidence about in the pre-trial brief, witness summaries, or 65-ter list. In the absence of notice that these accusations were being treated by the prosecution as unscheduled incidents, the trial chamber erred by treating them as such. Contrary to the prosecution's suggestion at paragraph 12, the use of inclusive language in the indictment is not a blank check to convict Mr. Mladić of any accusation made before the trial chamber. There must be limits as a matter of fairness. The appellant submits that it is contrary to the most basic principles of an adversarial criminal trial if any accusations made could fall within the scope of the indictment without notice. The prosecution must identify what case and which incidents it seeks convictions of, so the defence can defend against each incident specifically accordingly. The presentation of a general defence or cross-examination did not cure this error. Absent notice and specifying the crimes alleged, the only defence available is a general one. And a general
Yes, Ms. Bagot, would this be a nice time to take a break for 1 hour?
Yes, this is a convenient moment.
Very well. The proceedings will pause for 1 hour and we'll proceed. What's the time now?
It is 11:30, 10.
So we'll resume at 12:30?
Madam Presiding Judge, will be 11:30.
Sorry, my time is 11:30 about. It's the same time as The Hague. No?
No, it's 10:30 now. In fact, it's 10:31 now. We should be resuming at 11:31.
Oh. So it's 10:30 there. Here. No, my phone is saying, yeah, okay, 11:30 my time, we resume.
All right, veuillez vous lever.
Thank you.
It's like, hello. Am I going too fast? Are you sure?